privilege to serve since approximately 1998 as outside counsel to the New Hampshire Site Evaluation Committee. Mr. Drew gave me a call last week and asked if I could come to this commission and speak to you about the Site Evaluation Committee. And I told him I'd be more than happy to do so. I brought and I passed out a couple of fairly basic level handouts dealing with the Site Evaluation Committee. These handouts I used in a continuing legal education seminar for the New Hampshire Bar Association back in October 2009, and they basically provide just sort of a brief overview of the committee, what the committee consists of, and how it operates. It is geared a little bit towards lawyers and lawyers who might appear before the committee, but I believe it would be useful for your commission as well. I am not sure, with respect to each of you, to the extent that that you're aware of the Site Evaluation Committee and how it operates. So I figured I would just start off with a brief overview and then let you all ask any questions that you may have. I've read your charge. I'm not sure that the Site Evaluation Committee has any direct statutory issues or authority with respect to determining if certain routes should be designated as routes, but I'm more than happy to answer any questions that you have about what the Site Evaluation Committee can do, might do, or any other questions about the Site Evaluation Committee and transmission routes within transportation right-of-ways. The Site Evaluation Committee is designed by statute as a sort of one-stop shopping market for the permitting for energy facilities. The jurisdiction of the committee generally begins with energy facilities, and energy facilities include things that create energy, such as a wood-powered burner, wood-fired burner, such as a nuclear power plant, such as a wind farm, and transmission facilities. And the primary jurisdictional aspect where the Site Evaluation Committee becomes involved is at the level of 30 megawatts. There is, for renewable energy facilities, a area of discretion where the Site Evaluation Committee can exercise its jurisdiction with respect to renewable power projects, and that is between 5 megawatts and 30 megawatts. However, in general, and I believe for most large-scale transmission facilities, the 30 megawatts is really the number that hits. And with respect to pipelines, the jurisdictional issue is whether the pipeline can service an amount of fuel that would be the equivalent of 30 megawatts. And those statutory definitions are contained right in the Section 2 of RSA 162H, which is our enabling law for the Site Evaluation Committee. The committee itself consists of the commissioners or directors of a number of different state agencies, pretty much every state agency. I think the only major agencies that don't appear to be on are corrections and safety, probably a good reason. But the commissioners or directors of various sub-agencies within those agencies sit. It is a 15-member commission. Thanks to some changes in our enabling statute back in 2009, we don't require all 15 members to sit any longer. We can create subcommittees of at least 7 members. We usually try to have 9 in case of illness or somebody leaves their job. So that the committee has this sort of one-stop shopping. And that doesn't mean that somebody who applies for a certificate of site and facility, which is the approval authority that the committee gives, we actually provide a permit. That permit is called the Certificate of Site and Facility. a developer, whether it be a transmission line developer or an energy facility developer, still has to go to the individual state agencies and file their permits that they would normally need. So for instance, if there was going to be disruption of the land as a result of construction, they would still have to file an alteration of terrain permit with the Department of Environmental Services. If it was an energy facility that was going to be producing emissions, they would still have to get an air permit. They still have to apply for an air permit through the Air Resources Division of the Department of Environmental Services. There are other issues where Fish and Game might be involved, or the Department of Resources and Economic Development, or the Department of Historic Resources. All of these departments are in fact represented on the committee, but there's still an individual permit process that the developer has to go through. And what typically happens is the developer will get all their ducks in a row before they come to any of us, sit down with the various state agencies. Sometimes they involve themselves with folks like Mr. Drew in a pre-permit planning meeting to figure out what permits they might normally need under the law. And they will file their permits and pay the permit fees that go along with them to those agencies. They then generally file an application with the Site Evaluation Committee, and I have a picture of one in the handout. They're usually large applications, and these applications generally include all of the, this particular one is from a wind facility, but it's, I'm sorry, it's on page, pages aren't numbered, but it's like the 9th page of that PowerPoint handout. I'm sorry, I gave you guys black and white.
It's like a law library.
Yes, they do. And in fact, this is not even the largest one that we've received. This is one that I happen to have in one place at the time that I wanted to take a picture for the CLE. But they file all of those applications for permits with the individual agencies. They pay all their fees, and then they file it all with the Site Evaluation Committee, who acts as sort of the supermarket where all of these things are resolved. And in our statute, we actually have the authority to require the state agencies to provide reports to the Site Evaluation Committee. The first report is generally due within 90 days of acceptance of the application. And that's what we ask for: draft conditions and a draft report as to where the agency is with respect to the application. And to also advise us of any additional information that they might need. And that's at 90 days. And then at 180 days, we expect the agencies to file their final reports and issue their permits in a draft format in most cases, but their permits to be submitted to the committee. If a state agency requires conditions, or if a state agency says that this project does not qualify for its permit from that agency, then the Site Evaluation Committee must either adopt the conditions from the state agency, and if the state agency says, sorry, we just can't grant a permit for this, for what they're proposing to do, the Site Evaluation Committee is required to deny the application for a certificate of site and facility. So that there is this interaction between the Site Evaluation Committee and the various state agencies that would have permitting authority. But as you can imagine, with respect to large industrial facilities like transmission lines, like energy facilities, there are a whole host of other issues that aren't actually covered under any particular type of state permit. A lot of the wildlife issues, they're not really, there's no permit that a developer goes and seeks in order to build in an area perhaps where there might be endangered species. There's really no agency that determines whether or not a project should be built or not based upon its visual aspects or based upon its aesthetics. And there are a whole host of environmental considerations that are not subject to any particularized permit. And all of those issues are generally contained in an application before the Site Evaluation Committee and dealt with by the Site Evaluation Committee during its process. And its process is a combined process. We begin each application, hearing on each application, first making sure we have what appears to be all the information that we need. So we have a 30-day acceptance policy where we check with all the agencies, make sure they have what they need, make sure we have what we need, and then determine whether or not to accept the application. Once the application is accepted, the next step that the Site Evaluation Committee undertakes is a public hearing. And at that public hearing, it's really, our public hearings at this stage have two parts. We require generally the applicant to be there to answer questions from the public. And we also allow the public to weigh in and give their opinions. So generally these hearings take place in two parts. The beginning is sort of a presentation from the applicant, the developer, and then we make them take questions from the public. And then anybody who wants to speak, give their opinion or whatever to the committee is permitted to do so after that. By law, we are required to hold at least one of these public hearings in each county in which the facility is proposed to exist. These hearings, and this isn't by statute, but generally the Site Evaluation Committee has conducted these hearings in the evenings to make them as available to as many local residents as possible. It has also been a tradition, although it's not required by the statute, that what we've done over, I'd probably say the last 5 or 6 years at least, is on each of these occasions, we've usually taken the day of the public hearing, put on our boots and our jeans, and have actually gone up and done site visits, if possible, to the areas where the energy facility is expected to be built. For instance, there's an application before the committee for the Antrim Wind project right now. Earlier this year, on a beautiful day, just lucky, we wound up in the hills in Antrim, stomping around with I think 9 committee members, probably 30 people from the press and the public, and to see the actual area where the facility is proposed to be built. And like I said, that's not a requirement of the statute, but it is something that the committee has more or less by tradition undertaken to do, because it does give the members of the committee a good idea of where is this place, and what will be the impacts, because that's ultimately the findings that the committee must make. The second part of our proceedings are a little bit different, and they're different than the way the federal government does a lot of permitting as well. We actually then go into what we call an adjudicative process, where we actually have a trial sort of. It's not just like a trial in court, but it's very similar to a court trial. The applicant has the burden of proof to demonstrate that the proposed project satisfies the statutory criteria. We have, in every one of those cases, appointed from the Attorney General's office an Assistant Attorney General who is designated as counsel for the public. And counsel for the public has the role of protecting the public's interest with respect to, primarily with respect to environmental issues that arise, but counsel for the public has also weighed in on lots of other issues that arise in these applications. And I will tell you, every one of these applications has its own set of unique, a lot of them have very similar issues as you've gone through, but a lot of them have their own very unique issues. The biggest example of that comes with the wind facilities that come before us, because depending upon where they're located, the issues that arise can be entirely different from one project to another. The adjudicative process is just like any other quasi-judicial administrative proceeding. We have automatically 2 parties involved. So it is what the Administrative Procedures Act calls a contested case, and that is obviously the developer or applicant and counsel for the public. We allow parties to intervene if they can demonstrate that they have a substantial interest in the outcome of the proceeding, and that's under basically black and white administrative procedure law in the state of New Hampshire. We have the Antrim Wind application, which is pending before us right now. I think in addition to counsel for the public and the applicant, I think we have like 6 other parties who have intervened and have been granted intervener status. Some of those are groups of individuals who live near the project. We also have, for instance, the Audubon Society has intervened, the Appalachian Mountain Club has intervened in that proceeding. And each of these parties participates. They get to cross-examine witnesses, they get to put on their own witnesses. And all of that is towards the assisting the committee to make a decision on whether or not the application that's pending before the committee satisfies the statutory criteria and whether or not the committee should grant a certificate of site and facility. The Site Evaluation Committee works under strict timelines. For a traditional type of facility, one that's not considered to be a renewable energy facility, we must go from acceptance of the application to a decision on a certificate of site and facility, whether to grant it or to deny it, within 9 months. On a renewable energy facility, and they are defined in the statute, the classic ones that we get all the time are the wind facilities. We have to complete our entire process from the date of acceptance of the application to the issuance of a decision within 240 days, which is 8 months. And there are timeframes within those timeframes as well. I've already referenced 2 of them, the filing of draft reports from the state agencies and the filing of their final reports. There is also some notice requirements in there that we have to comply with, which makes the actual decision time for the committee, in most cases, basically it's that last 30 to 60 days when the committee does the bulk of its work. It's done a bunch of work in the beginning with the public hearings, but we hold adjudicative proceedings and have to get an order out pretty much in that last 2 months. That makes sense because by that point in time we should have a substantial record in front of us, and we usually do. In fact, we always do. And what basically what the committee has to consider is on the last 2 pages, I'm sorry, of the handout. These are right from the statute. And before it can make a decision, the committee must consider available alternatives. It must fully review the environmental impacts of the site or the transmission route. And it must consider all of the other relevant factors bearing on the purposes of RSA 162. And then it has to make certain findings, and those findings are on the last page. Before it can grant a certificate of site and facility, the committee must determine that the applicant has adequate financial, technical, and managerial capability to construct and operate the facility in accordance with whatever terms or conditions are ordered by the committee. The committee has to determine that the facility will not unduly interfere with the orderly development of the region, with due consideration being given to the views of municipal and regional planning bodies and municipal governing bodies, and that the project will not have an unreasonable adverse effect on aesthetics, historic sites, air and water quality, the natural environment, and public health and safety. And ultimately, if the committee determines that each of those things is satisfied, it will grant the certificate. If it determines that there is some issue, it will deny a certificate. In most cases, the committee has granted certificates with a whole bunch of conditions, some of which have been problematic for developers, some of which have not been. But nonetheless, that's sort of the process that we go through. I don't know if I've missed anything. There is a whole history of the Site Evaluation Committee. There's a little bit of it in the written document. There's a better history of it authored by Mr. Drew on the Site Evaluation Committee's website, which is, you can find by going through the state's website. And I'm more than happy to answer any questions that you have about the committee and how it might fit in with your charge here today.
That was great presentation. I really appreciate that, Mike.
Thank you.
Thank you, Mr. Iacopino. You used to be chairman of the
That was
PUC.
my daddy.
Oh, was your dad?
Yes.
All right. I'm saying, all right.
Look a little young to share the PUC when Seabrook came online.
Yeah.
because that's when he was chairman.
All right, you know, I just couldn't reconcile that. But anyways, what emphasis, what weight would you put on a project that came in which was a necessary project, or a project that was an elective project? Would that have any bearing in your permitting process?
Well, right now I have to say no, because I don't think that anybody has ever made the distinction that something is elective or necessary. In a way, most of the recent projects have all been elective because they're all merchant facilities that have recently come online have recently come before the site evaluation committee. I mean, all of the wind farms that have been applied for, I mean, there's nobody coming in saying, I mean, in a sense that there's some law or something that requires this to be built. Mm-hmm. So I think that right now, in the way the energy market is, virtually everything is elective.
Further question?
Sure.
Yeah, ISO had testified that the transmission project that in the north part of the state was an elective project, or in other words, the energy wasn't necessary to maintain the services of the grid, and that's where that question came from. I'm looking at your requirements here, and one of the things that you do look at is environmental impacts and so forth. The state has put a value on view, and property owners pay a portion of their taxes based on what their view is. If a project were to interfere with that property owner's view, how would you balance that? Would you require a developer to compensate that property owner for the loss in value?
First of all, it's not me, it's the members of the committee. Mm-hmm. I just get them going. In applications before the site evaluation committee, it is standard to have a visual impact assessment prepared on any project that's above ground. I mean, we even have it prepared for projects that are not transmission lines or not wind facilities. And the committee considers whether or not that change in the view shed is an unreasonable adverse impact. If it determines that the change in the view shed is an unreasonable adverse impact, it can deny the certificate. If it did, and that comes under, in our statute, the issue of aesthetics. Okay? Because the project cannot be permitted if it has an unreasonable adverse impact on aesthetics. There has not been nobody has ever brought to the committee sort of this, I mean, the view tax issues have been raised by folks, in the same way that you have, but it's never really been a litigated issue as to whether people should receive money for the fact that their private view shed has been somehow impacted. I think the feeling is, although this has never come out in any of our decisions, I think the feeling is that if there is such an adverse impact, that person would go to their local town if part of their assessment is based on their view, and that their property assessment would be reduced.
So the town would subsidize the utilities diminution.
I'm saying that's the way that I think the feeling has been when individuals have come to us and said, this is going to ruin my view. Now again, there's nothing in our statute that says we have to consider it that way. But I'm not sure that our statute actually authorizes us to find a taking, which is really sort of what you're talking about. Mm-hmm. What you're saying there is that the private entity that's putting in the transmission line or the windmills, which are they're much taller than most transmission lines. They've taken something away from the private landowner, and therefore they should have to compensate them. That I know we have no statutory authority to do.
What further questions? Sorry. What type of legislation would you foresee that would accommodate a taking? And do you believe that that would be prohibitive in developing new projects?
Oh, well, yes, I think it probably would be. I think that the way that energy facilities have been permitted in the state of New Hampshire for a very long time now has not had that component in it. So I do think that that would make developers take a step back and say, am I going to have to compensate everybody in a 5 square mile or 10 square mile area because they may see my project. I will tell you there was one project in 1998. It's I looked to Mr. Funstein because he represented the applicant. It was the power plant built in Londonderry, and there were in that as part of an agreement amongst the parties. There was a buyout agreement for some of the local homeowners. But that was done by an agreement of those parties. The Site Evaluation Committee did rely on that agreement in granting the certificate, but that was not something that the Site Evaluation Committee specifically came up with and ordered on its own. But that was the result of an agreement between, at that time, it was AES owned the facility and the people who lived in the area.
Further question?
Wait a minute.
The committee must determine whether there are available alternatives.
The committee.
Yes, the Site Evaluation Committee must determine if there are available alternatives. Sometimes people come to us with alternative A and alternative B as part of their application. And the committee has decided, well, we like A or B better. But what the committee cannot do is the committee cannot say, okay, you've come to us with one proposal, it's this corridor or this site. We think it would be better if it was built on the other side of the ridge, okay? So go build it there, because that's not what's applied for. And we can't tell a private entity to go buy some other land. What we can do is deny the certificate, okay?
How do you determine if a project has done, I guess it's due diligence in terms of looking at other alternatives, or you don't do that? You just say, this is what's before us, this is what we're looking at?
We require them in every case to, that's actually part of the application process, is to, and they have to put it right in their application, is to define and list the alternatives that they have considered to their particular project.
What's in that consideration when you say that the other alternatives that they considered? Under that consideration, do they have to prove out economic value or cost or anything like that?
Generally, they do. I don't think that our regulation is that specific that would require them to address the financial aspects of it, but we do require them to tell us all of the alternatives that they have considered, and depending upon the type of facility, they can be different. But for instance, with Groton Wind, there was an alternative that they had presented to us to go to hook out with 2 of the turbines in a sort of different configuration. There have been, I hate to say this, but in for small strips of putting, they're not technically transmission lines, they're lines that carry the electricity from the energy facility to a substation underground. There have been alternatives like that that have been discussed and considered. And we require them to list them, and the committee can find that there has not been enough investigation of alternatives, and on that basis not grant a certificate.
I just got one more. So, and then I'll let you go. So, what you just said then, to me, really the Site Evaluation Committee has no ability to tell the applicant to do one thing or another. They're only judging based on what has been presented to them.
Right, and the reason is because we can't tell an applicant, you have to build it somewhere where they don't own the land. easiest way to put it. We can't tell somebody, you have to build it on the other side of the highway, the other side of the mountain. What does happen, though, through our process is if there is something that can be changed like that, and the parties see that this is what's coming down the road, oftentimes they do come, they amend their certificate, and they make changes. That happens in, I would say, more often than not through our process.
Yes.
I'm Will Abbott from the Forest Society. I was curious, when there's a project that involves federal permitting as well as state permitting, do you have the authority to wait on any action until the feds have made their decision? Or how do you decide how to handle an application that requires both federal and state review?
That implicates two parts of our statutory authority. Once an application is filed with the committee, we are under time frames. We can extend those time frames if the committee finds that it is in the public interest to do that. And I can envision an aspect where there might be some big federal issue that is being decided by a federal agency, and the site evaluation committee determines that it's in the public interest to have that issue decided by that agency before proceeding with our process. So that's one aspect of the authority of the site evaluation committee. The other aspect of the authority of the site evaluation committee is we are specifically authorized. I can't cite a chapter and verse for you right now, but we're specifically authorized in our statute to make a contingency or condition of any certificate that we might grant that they comply with some regulation or some opinion or authority of the federal government. We also are, this isn't exactly on point because it doesn't involve state federal, but we also can delegate to individual state agencies the monitoring of the project in their particular area. So for instance, in almost every case if there's going to be an air issue, we will designate to the Air Resources Division the authority to monitor compliance with the certificate. So we can do that. But the two areas where you're talking about is the committee could, and of course it depends upon the timing of all the filings and whatnot, determine that it's in the public interest to suspend our proceedings pending the resolution of something because that's in the public interest. Or the committee could say, if they decide that otherwise this project would warrant a certificate, we're granting the certificate subject to the actions of the United States Fish and Wildlife Service or whatever it is. It's filed. Let me just back up. The Site Evaluation Committee consists of the 15 members of the committee who are all commissioners. There is no staff. There is no budget line. It's assigned to the Department of Environmental Services for the purposes of keeping the records. But there's really not any kind of budget given to the committee. Each of the commissioners and directors that sits on the committee, it's part of what their job obligations are when they take the job. It's an ad hoc committee in that they don't have a standing staff. They only have a staff when there is an application pending. That staff usually consists of 3 people. Outside counsel, because with the Attorney General's office being involved as counsel for the public, there can be all sorts of conflicts involved if they're also representing the committee. So the committee will usually hire outside counsel. As I said at the beginning, I've been very fortunate to be that outside counsel since approximately 1998. I get hired on a case-by-case basis. I've done lots of free work for the committee because it makes sense and I sort of know these things, so that I can come to things like this and speak about it. And that way my commissioners and directors don't have to put themselves on the spot and perhaps be asked questions about what they would do in a certain circumstance. There's also a secretary that we hire on a case-by-case basis who basically keeps the information flow going. So when somebody files a motion, right now it's a she makes sure that it gets to the committee members, makes sure it gets to the parties, runs the website, and keeps all of that going. She is an employee full-time of the Department of Environmental Services, but they charge for her time to the applicant, as my time is charged to the applicant. And the third person is a stenographer. We generally use the PUC regular stenographer, who is an independent contractor, who also bills the applicant for the time it takes to transcribe and prepare transcripts. This is not, for me, the best thing to say to this committee, but I would urge this committee and any other public committee, and I'm speaking from my own experience and not on behalf of any member of this committee, that I sincerely believe that this committee should be brought into state government and be supported on a more on an agency basis. I think it's a committee that should have staff and should exist, not just on an ad hoc basis, but I would leave it up to the legislature to determine if that's what you want to do and how you would do it if you wanted to. But and of course, that would take me out of the picture because we would probably be sensible and have as part of the staff a lawyer who's assigned to that committee, who probably is going to be less expensive than what the applicants pay for me.
My point was not to get
I'm sorry.
at who pays your salary.
Oh, that's okay. The applicants
But
do.
the committee is funded in part by utilities. PUC is funded. So the money trail, so part by utilities, part by the applicants. So every study that you demand or everything that you tell them that they have to go and do, this falls back on the individual applicant
Yes.
to pay for that study and then present it.
Yes. I don't know that we get money from utilities. though.
Well, the PUC is funded, if I'm not.
Right, and the three PUC commissioners
So
and
the
an
three
engineer
commissioners.
are on our thing. Same way, I mean, the DES folks that are on our committee are funded from the general fund as well. Well, all of the committee members are. But yes, for anything that's above and beyond them doing their job,
Goes back to
goes
the
back to
applicant.
the applicant.
Thank you.
So Mike, are you saying you're recommending that another agency be created to?
Like I say, I don't know that this is within your charge here, but I've said this before, and I said it, I believe that it's an agency that should be full-time staff. I have no problem with the membership of the commission, but that commission should have, that committee should have staffing, and it should be full-time, and quite frankly, you can do it at a cheaper expense for the applicants and the people who are paying right now.
Any other questions? Thank you, Mike. That was great.
Thank you.
Appreciate your time.
Again, those last views are clearly just my own and not anybody else's.